Let's check it one more time. I just turned it off and on for the YouTube stream. And
there we go. It looks like it says upcoming
office hours scheduled for this.
at 6:02.
Oh, yeah, it's there now. We did it.
All right.
Live on YouTube as well. All over the world now.
I'll watch for questions on them.
Yeah, YouTube one should pop up here. It's only the Instagram ones, I think.
That's the one where we got those weird spam ones.
Oh, yeah, it's from YouTube. Let me see. Test comment. I'll do that on the YouTube one and see if that pops up for us here. Yep. All right, so we saw that one. And then let's check the Facebook one here.
Yep.
And see if that one pops up as well. There we go. We are officially working and living. Okay, so we'll probably spend a little while on this topic, so I'll go ahead and dive right into it here, and I'll introduce it, and then I'll share my other screen so that we can talk through this California Fair Plan update. I feel like we talk about California Fair Plan more than anything else. So over the past couple of months, we've spent a lot of time talking about California Fair Plan because it is the most, wild card insurance company when it comes to these wildfire losses in Southern California, especially for people whose houses are still standing, that have partial fire damage, that have combustion byproduct, fire debris, lead, asbestos damage. They have really been just dragging their feet. Essentially, they either have been like partially denying things or sending out other vendors, taking forever to write estimates, reassigning adjusters, and really just seeming like they're dragging their feet. And so there's an update this week from a pretty high profile attorney. He posted on LinkedIn kind of a big update with a denial letter that they received on one of their claims. And so I'm going to share my screen and we'll dive into what that one is here. Let me see. All right, here we go. All right, this is going to be a little bit difficult to see, but I'm just going to read it for everybody here. But if you do want to see it, actually, I'll go ahead and post the link to this post in the chat of the various pages so that people can see them right now. Let me see. Put it in Facebook there, and I'll put it in the YouTube stream as well. So this is from Dan Verhoff. He is an attorney with Merlin Law in California. So Merlin law firm is run by Chip Merlin out of Florida, but they're nationwide. They have law firms. I don't know how many, but I think at least several dozen across the nation. And I think their only focus, not just their primary focus, I think their only focus is first-party property claims. So a ton of experience. He's a pretty well-respected voice on this matter. And so I'm going to read this post and read some of the language from it, and then we'll talk about why this is so relevant to so many people right now. So it says California Fair Plan officially refusing to pay claims for smoke, lead, asbestos, particulate cleaning. And the denial letter is attached. Until today, Fair Plan has avoided confirming or denying coverage for Palisades and Eaton smoke, lead, asbestos, etc. contamination claims, even for homes centered in the burn zone. Look, we're already getting the spam comments from YouTube. And they come in fast. Anyway, even contamination claims, even for homes centered in the burn zone. Fair Plan's new decision to deny these claims came quickly after the California Supreme Court refused to depublish the Caribbean decision, which held there was no coverage for light smoke damage to homes miles away the fire zone. This is from a past fire, but the decision came on the Caribbean case, the initial decision right after the Palisades and Eaton fires. So it was really relevant. This decision does not support denying claims in or reasonably close to the fire zone. Fair Plan is also citing policy provisions that provide less coverage than legally required in California under Insurance Code Section 2071 and another Planet decision. All these claims probably will now go to litigation to see resolution, and this is what we'll be talking about here. In this particular case, Fair Plan hired the hygienists themselves, and the hygienist recommends extensive specialty cleaning due to lead and soot char ash. Here is the language from the denial. It says, if the hygienist recommendations call for cleaning, including cleaning of lead and or asbestos, and there is no physical damage to the property, there is no coverage. In this case, the hygienist report confirms that any residue or particulates, e.g. soot or ash, present in your home can be removed by cleaning, because there is no evidence of permanent physical changes to the interior of our insured's home. The conditions required for coverage are not met. Therefore, the Fair Plan must respectfully deny coverage for this smoke damage claim.
That language.
Isn't it crazy?
Must, and damage. There's no damage. It can be cleaned. It has to be abated.
Well, it's so funny. In its first sentence that he highlights here, probably not the first sentence of the letter, but the one that he quotes, if the hygienist recommendations call for cleaning, including cleaning of lead and or asbestos, and then it says, and there is no physical damage to the property. So it's separating those two things, and very much on purpose there. It's separating lead, asbestos, soot, char, and ash contamination from physical damage, which the implications of this are huge. We've talked about it maybe a little bit in the past, but if they can win cases like this and make that case that something being affected by a contaminant does not mean that it's damaged by that contaminant, that can go really far into water claims.
Yeah, it can go everywhere.
Right? Yeah. Your carpet and your drywall isn't damaged, therefore we don't owe for it to be mitigated. Right? It's just wet right now. Sure, if it stays wet, it'll get damaged, but that doesn't make it damaged.
Yeah. That came off that other case, the one that they referred to as Planet, because that was a COVID case about the presence of COVID not constituting damage, and we're still seeing the effects of that.
Absolutely, yeah. And Aaron, if you have some familiarity, talk through what the COVID cases. They were mostly business claims. Right?
Yeah, so it's not even most of them. So a lot of them were, because there was a lot of business loss, and people rudely awakened to the fact that, even if they had, business interruption coverage, it's predicated on the policy first becoming active and coming into effect, right? You needed a covered cause of loss, you needed direct physical loss to the property. So when they were shut down, and they weren't getting their coverage, that was just, and that's what the policy covered, but it was obviously just because of the way that insurance works, people just weren't as aware of what their coverage meant. But there's other cases where the attorneys tried to make the case that there's this presence of this virus that now renders things unusable. You can't eat in this restaurant, it's no longer usable for its design purpose. It's altered, so now it's not covered, right? So, or now it's damaged, rather. And that was struck down, and that's that Planet that they're referring to. I can't remember the actual name of the two parties in the lawsuit, but it was something versus Wild Planet or whatever it was. But that ruling it keeps rearing its ugly head as a reason to in this case, right? They're denying the presence of smoke as damage because the presence of the COVID-19 virus wasn't damaged. The president of Soot and Ash isn't damaged. And it's just like, even though that may have been the right call in the context of that case, like now it's being weaponized.
Yep. Yeah, it was. And there was a big effort in lots of different cases. And I know United Policyholders was involved in a good amount of trying to advocate for some of these because business owners were put in a really tough position. They were forced to close. And I think there were other arguments as well that had to do with government mandates for having you close down.
But again, right, like it's typically the way that the policy is structured.
Yep.
You have to have the policy isn't activated until you have a direct physical loss.
Yeah. So anyways, yeah, desperate people filed desperate claims trying to make the best argument they could for coverage. There was a comment I saw recently that I think is made pretty often after cases like this that essentially say bad cases make bad law. Right. And so these cases that are, I don't know, maybe you call them fringe arguments, like really far-fetched ones. And I think there are some that actually won the argument in some states, but it was really rare. I'd have to look that up. But people were filing lawsuits just to try and get something, right? Because they were so desperate. The problem with that ended up being that when it's determined that, you know, this isn't a valid claim, then there's the implications all the way down the road for why this isn't, how does this now relate to, as we're talking about, smoke damage, soot, char, and ash contamination, something that's completely different, right? Like with COVID, we're talking about a virus that it turned out didn't live on surfaces. It wasn't maybe known at the time.
They mentioned that case in here. I thought they were mentioning the one where the smoke damage wasn't approved in California. Like, or was that smoke damage not approved in California one based off the COVID one? Is that what you're saying? The one that just got lost a few months ago?
So where did it reference Planet in the thing that you just read?
It says in the beginning of Dan's post.
Okay.
It says the decision does not support. Fair Plan is also citing policy provisions that provide less coverage than legally required code under the insurance code, and they're referencing, it says, Another Planet decision.
Oh yeah, Another Planet Entertainment LLC versus Vigilant Insurance Co. That's it. It's a 2023 case.
Okay.
And then but that one also got referenced, in the smoke one. So okay. It was like, it was. But yeah, this argument just keeps coming.
The bad case is making bad law. Like what that does is say you have an insurance claim that really shouldn't have been approved in the first place, and you decide to sue for it anyway, just to try and see if you lose that case. What that does is it sets a standard for everything else that follows it. And so if anybody else has a case that even sounds vaguely similar, then the insurance carriers will start pointing at your case to be like, well, theirs was denied, so we can deny it even further. And this smoke claim that this whole thing is based off of seemed like it was a long shot type of claim. Like it was probably just an attorney.
Well, and it was actually covered too. They had covered that.
They covered it. They just wanted more coverage.
They wanted more coverage. Yeah.
So it backfired, and they got full denied coverage, and caused this whole cascading effect for thousands of people right now that are going to be affected by that decision.
Yeah. Many thousands of people. And I've read some opinions on the case as well. And this is where I think some of the risk is. And again, none of us are attorneys that are here. Maybe Cody will hop on and be able to speak to some of this. He's been hopping on the last few weeks. I sent him an email so he can join if he wants to. Chris, you can shoot him a text. Maybe he'd have some comments.
Today.
What's that?
He's on inspections today.
Oh, yeah. I know he was on one earlier, but I forgot he had another one. Anyways, gosh, I can't remember where I was going. Sorry. We were still.
Well, you were commenting on like us not being attorneys, but are you going to say like some of the risk in us talking about this? Was that where you're going with that?
Oh no, I was just saying that before I made any more comment about.
But I mean, there is something there. Like we should I'm not even sure. Like, yeah, how much can we even dive into our understanding on these? But like the effects are real, right? Like even
Yeah.
if we aren't qualified to speak to like the legal proceedings and whether the cases were adjudicated well or whatever, right? Like the outcome is like clear, right? They're being applied in situations that like are irrelevant.
Yeah. And I just remembered the point I was going to make. So this is what I've been told by Cody and other attorneys is that one of the risks in taking any property claim to court that makes it sometimes feel like a little bit of a wild card is that insurance is this complicated, convoluted set of rules and regulations that oftentimes it's essentially seems like the court doesn't have a full grasp of the context of what they're making a decision on, right? And what the implications of it are, and not just what the implications of it would be, but what's involved there. And so unless before I ever worked in insurance, I didn't know what abatement was, didn't know what asbestos contamination was. I didn't know what any of these things were, right? And then let alone how those things vary within a policy, how those things are commonly understood within the industry. And not that these arguments aren't made when a case is being adjudicated, but essentially the sentiment that I've heard from several attorneys is that, every time you're putting something before the court, it can feel a little bit like a wild card for that reason, right?
Well, yeah, think of a judge that's seeing every kind of case that comes through, and he just did a domestic violence case before you walked in, and now you're giving him an 80-page contract with very nuanced language, and he's not a contract attorney or a contract judge. And so like if he can't wrap his head around the difference between a covered loss and like the wear and like if he can't figure out the difference between wear and tear and damage and the way the contract is written, he's gonna rule it completely opposite of what the actual policy is even saying, because he can't understand it.
Beyond that, even you used a good example, Chris, because you called out specifically like a family law attorney, right? Or a family law judge. And like family law has different rules than criminal law, right? And it's like policies, insurance operates on different rules like entirely than any of those, right? It's these like social contract rules of good faith and fair dealing. And it's like that's not what you're dealing with in a courtroom. Like you've already lost, like the venue changed. Like we were supposed to have a utmost good faith contract in which like there's these general rules about what it means to conduct yourself fairly. And now it's a battle, a legal battle, zero sum, winner takes all. And it's just like, it's a totally different venue. Like cases don't belong there.
Yeah. We even see it, all of us that have worked in public adjusting. How many times have we had conversations with attorneys, like say a client has an attorney that they talk to because that attorney has helped them with something else that they had going on, whether it was, a family law dispute or some other civil dispute. And they'll be like, oh, my attorney just said to go ahead and file a lawsuit about this. And I've spoken to those attorneys before. And after a conversation, they'd be like, oh yeah, I just totally didn't understand how this dispute worked, or what the appraisal clause is, and because they'll say like, well, why don't we just take it straight to mediation, or why don't we just appraise it, because that means something different even in a auto policy rather than it does in a property policy, right? So there's all that to say. These cases, especially ones where the arguments are a little bit fuzzy like this. I haven't read the full Gribbian decision, and I should, but I know exactly the context of claims like that. When there is soot and ash that falls on houses that are miles and miles away from a fire. I've lived in a house where that happened before. I lived in Tarzana, and a fire happened. I think it was like all the way in Somar, but it was super windy. And the next day there was a ton of ash on the house that we lived in, and on our cars, on all our stuff outside. Some of it probably blew in around the windows. And maybe there's a claim to make there, right? And people make those claims. And there are professionals and public adjusters that have whole careers off of essentially just arguing those claims, right? And trying to maximize them as much as possible. Those claims are often equated with people that, I don't know, chase really minor hail damage and things like that are outside of like the heaviest hit hail zones. But we showed a video several weeks ago, and I've posted about this, that the smoke damage claims that we're talking about with these wildfires and that Dan is talking about in the denial letter is one that's in the burn zone, which means that you're surrounded by houses that burn down, and the stuff that blew in and around your house, as confirmed by the hygienist, is like hazardous material, right? And there's one thing I wondered too with the physical damage provisions. You know how you can take a microscope?
I was thinking the same thing.
You can take a microscope and look at most materials where even just charred ash has sat on them for a period of weeks, and you'll see what's that?
Like delaminates the material.
Yeah, it starts to eat away at the material. Wood finishes, even metal. I've seen people posting photos of those lately. It starts to make physical changes. Now, you're obligated to mitigate against further damage. I'm wondering how this plays into cases like this, where CFP dragged their feet for 3 months now, 4 months to do anything, to make any decision as to what was covered. You likely haven't done anything then yet, because these decontamination estimates are tens and tens of thousands of dollars, upwards of $100,000 sometimes. So you couldn't afford to. And then if you were to go back in there now with a camera, you could show physical changes to the property from all of this that are now worse than they would have been if they had paid the decontamination bill at the start. So I wonder if there's a way that you'll be able to follow up on some of these, or if they'll fall back on your duty to mitigate.
Yeah, they'll come back and be like, well, you should have cleaned up from the beginning. Like, why didn't, just because we didn't cover it yet? Like,
Yeah.
Emily said she's glad that she secretly glad that she had minor damage. She didn't get left behind kind of situation. That's unfortunately the situation. Like, the people that actually had damage to their home are in, funnily enough, a better situation and a better spot to get help.
Yeah. I mean, it's been the conversation we've had from the beginning, and it's why we've talked so much about claims like this from the start. The total loss claims, though they are complicated and plenty of them need representation still, and most of them weren't paid their policy limits, all those issues are real. With the smoke claims, many of them are just finding out that they're not even covered for it according to their insurance company. Not according to the policy that was given to them, but according to their insurance company. Aaron, talk about for a second too, Dan mentions it in the post that we read. Essentially, CFP's policy, he says, is illegal, and contains language that the California Department of Insurance has said. The California Department of Insurance says it does not meet the minimum requirements for offering insurance in California. Therefore, it's illegal. And the Department of Insurance came out and said that case, the Caribbean case, does not and should not affect these claims. What is that saying about insurance companies and their relationships to the Department of Insurance?
Oof, that's heavy. They're largely declawed, right? There's not a ton, even if you looked at the statement from the commissioner's office, it starts out strong and then kind of peters out, because their limit of authority, at least in the way that it's being interpreted and extended, it is pretty strict, right? And once bad faith, once a bad judgment, once a wrongful denial has happened, like, it's almost too late for them to help, right? Like, their job is to catch these things on the front end. Their job is to make sure that the contracts, adhere to the code, make sure that this language doesn't get in there. In this case, it's apparently it got through, maybe on a mistake, maybe on another reason. They got language out there that didn't meet that minimum requirement, but like their mandate is essentially like, and where they have the most power is to approve what language makes it into the contract. And it's the same reason that like them changing how they apply coverage later without changing the language in the contract is just a way for them to sidestep the regulation. Because like it's like, oh, hey, we don't want to cover this anymore. Well, now typically you'd have to submit your policy to the state to get reviewed and approved, and they'd kick that back and say, no, you still have to cover that. It doesn't meet the minimum requirements. And instead, they're just like, well, what if we just like pretend this means something else now? And that's been the game. It's like, it's crazy. They're all playing it, and it's just like, hey, we're not gonna submit our policies for review anymore. We're just gonna keep using the same policies and just like reinvent language.
Yeah, change what it means. And I'm trying to remember, I think it was David Princeton that had explained that, gosh, I want to say this accurately, that when a carrier submits new policy language, they simply have to say that they're not diminishing coverage while raising premiums, and that language typically gets approved, right? So if they're just changing,
it doesn't get scrutinized unless they're admitting to lessening coverage.
Yeah, exactly. And changing a definition, they likely wouldn't see as diminishing coverage. They would see it as refining coverage, right? And making it more explicit. Yeah. We can dive into a little bit. Well, actually, no. Aaron, share this. Danielle, did you have any thoughts? Sorry, I thought you were trying to say something first before I have another question for Aaron.
No, I wasn't trying to. I'm just like blown away by all this.
Isn't that crazy?
Yeah.
It kept me up in bed the night I read this a couple nights ago. I'm like, oh no. Like I mean, it's a big enough deal. Like you guys have to let Waypoint clients know, right? I guess let me dive back into this. Aaron, remind me to ask you a question in a moment about the Department of Insurance and a follow-up in North Dakota. But let's come back before we get onto that into this California FAIR Plan denial. And what does it mean now? This is the question that most people should have. What is this? The fact that California FAIR Plan has officially taken the position that they're not going to cover decontamination work for when there is justified and recognized lead, heavy metals, asbestos there. They've taken the position that that's not covered. They don't have to pay for decontaminating it. Before, we thought that might be the bar, right? We're like, well, if we just need to, they say they don't cover smoke, let's just prove that there's not just smoke there. There's also lead, asbestos. Like that will certainly be considered damage, right? And now they're essentially saying like, no, like that's so.
They're sort of saying that a Procedure 5 is not damaged.
Yeah, that they're saying,
I was not expecting that.
No, I don't think anyone was expecting it to go that far.
Yeah.
Which is why, if anybody that is watching this now is like, can see on all our faces, like this is a really big deal.
Yeah. And also what I just said, Procedure 5 in Los Angeles County and some other surrounding counties, and if there is a certain amount of damage to an asbestos containing material that got released into the air, it's what triggers what's called a Procedure 5, which means that very extensive cleaning rules are put into place of how that has to be dealt with.
Yeah.
And so they're pretty much saying that doesn't constitute damage.
One slight clarification there. It's generally only if it's unexpected. So you can, if you know how much asbestos you're dealing with from the outset, it wouldn't trigger a Procedure 5. It's if it gets discovered in the course of the work.
Okay.
Yeah. Which is all of these, right? It's when it's getting discovered as these companies are getting ready to do decontamination work. And just so people understand what a Procedure 5 was, like if you saw one taking place, you wouldn't think a house is being cleaned, right? That's not the word that would come to your mind, because you'd see people in hazmat suits, ventilators, full containment barriers. Like it would be the whole 9 yards. You'd think that a crime scene was going on there is what happened. Because that's what it looks like, and that's what would be called for with this specific claim, most likely. So, anyways, let's talk about for a moment Danielle, Chris, for your clients that you're working with at Waypoint, Aaron, for the users at Tugboat, what are the implications of this for all of them? We're going to have to notify people of this decision, right, this week, and let them know, hey, this is likely what this means. Dan's opinion in here is that he says all these claims will probably now go to litigation to see resolution. He says all these claims, thousands and thousands of claims. He's saying
How,
are going to
how quick is it to get a claim heard in the
2
Los
years.
Angeles court? 2 years.
I mean, yeah, file, and even for the ones that we've seen filed, right? You file a lawsuit, you get your first hearing set within 8 to 12 months. That's going to get continued and delayed into the next year. And oftentimes, I have one from the public adjusting firm I worked for in 2021 that still has not gone to trial. It just keeps getting delayed. So that one's at 4 years.
And the sad part about that is, what are people supposed to do in the meantime? Just pay for an abatement on their own.
Most people
like
can't.
But the reality is that a lot of people are going to end up moving back into their houses because there's no other option. And that's the tragedy of it. And what that means.
And then the risk that they're taking by doing so,
Yeah, we've taken a handful of California fair plan claims just to see how far we can push it. And that means for these clients that we have to let them know that most likely that's not going to go anywhere. And would you like to speak to an attorney sooner than later?
Yeah.
It
essentially means that all of these, most likely, all of them will require involving an attorney. What that means for people is that they've already signed with a public adjuster. So they've already given up a percentage of their claim, call it 10, 15%, whatever those ones are signed at, right? Now they're going to have to go talk to an attorney who knows that they have a huge fight ahead of them because the courts have not been friendly to this case already. So it's not going to be easy. The insurance company's already taken a negative stand against it. They're going to put everything behind it. And so they're not going to take it at some light discounted rate, most likely, because it's not going to be easy. They shouldn't take it at one. So the average attorney's fee in California is 33%. It's a third. Some of them are as high as 45%. And so now for their decontamination claim after this traumatic wildfire, they're looking at signing over 40% of their claim, 35% of their claim, just to try and get to minimum standards, right? And I don't know if attorneys, and again, this is, we're not attorneys. I don't know if attorneys will be able to stick bad faith into these lawsuits simply from them being denied like this. If they have genuine dispute, because there is case law around it and the courts have been friendly to it. And so if bad faith isn't available in every single one of these, you're looking at just contractual damages. People will never be made whole, even if they win that court case, right? Maybe they have $200,000 in damage. They're going to have to give away $90,000 to their attorney if that case ever is won multiple years from now, when they all that time had $200,000 in work to do. So all that to say, this is not good news for homeowners, for property owners after these fires. It's never good news when someone is on the trajectory to have to file a lawsuit. I think a lot of people that aren't involved with claims or with lawsuits generally almost look at it as like, oh, I got to the point where I can file a lot. Like that must be good for them. They got to the point where they can file a lawsuit. It's just not that. Like it's almost never, ever good news that you got to that threshold that you need to get an attorney involved. It's going to take way longer. It's going to cost way more money, and it's going to be way more stressful. And for some of these people, like the implications, I'll speak to the one I was talking about from 2021 with an old public adjusting firm that I worked for. That family had severe severe vandalism damage. Joe, we'll get to that question in a moment. That's a really good question. That damage that was on that claim was vandalism that was denied by an insurance company in California. I think there was about $300,000, between $300,000 and $400,000 in damage. Almost all of it denied by the insurance company. And the home had to be nearly gutted for the repairs to be done, and the family couldn't afford to go out of pocket. They were retired to fix the house, so they had to sell it at a huge loss because they sold a gutted house in the middle of San Fernando Valley, and now are hoping that they get some of the money back in a lawsuit, but it's been 4 years, right? So that, I mean, that will be the reality for some people that are affected by, that don't want to move back into a house that's full of asbestos, right? They can't afford $100,000 in decontamination work. So the implications of this are really severe for some people, really, really severe. Let's throw this up here. Oh, Danielle's back. But the question's covering your face for a second here, Danielle. Just give us a moment. Joe Carl asks, will this decision emanate to other states? Now, this is when I really wish that our attorney friend was on the call. I'm going to give you my best understanding, Joe, and I am not an attorney. But I've seen how...
Thanks, Cody, for an answer. He's texting me right now. So.
I've seen how case law is utilized across states, and the way it's been explained to me is that there is a hierarchy of authority when it comes to case law, meaning that the closer that to the area where the lawsuit is filed and the claim happened, the closer the case law is to that area and that district, the more authority it has. And so if there has been a case relevant to yours that was decided in Los Angeles, in Southern California, and you have one of these claims in Southern California, it's super relevant. It's as relevant as it can be, right? And obviously there's a hierarchy of different levels of authority. So there's civil court, then you have appeals court, and you have state Supreme Court. All those raise the level of authority as well. But say you're in another state and you have this same issue come up, but that state does not have relevant case law to this dispute, then the attorneys can name case law from other states, and it will have some, not that you can't name it otherwise, but it doesn't carry as much weight as case law that is closer to that district, that area where the case was filed where the dispute is happening. So the answer is, I think the answer is that it could. Where I think your question, Joe, is, will this decision emanate to other states? Where I think the answer is certainly yes, is that when insurance companies make decisions like this, or other insurance companies see one be successful in doing something like this with claims, it affects the industry nationwide, right? And where you can see things like that are the endorsements that get added to a policy in one state. Once they're in effect there and insurance companies see that they're being effective there, and I would say restricting coverage oftentimes, then you'll see it added in other states, right? This is things like storm created opening endorsements, cosmetic endorsements for hail damage. So those are really common in states like Texas right now, but not super common in California. But I wouldn't be surprised if a cosmetic damage endorsement, which essentially in Texas and in other states that have them, means that if you have hail damage and it dents your metal roof, but it doesn't cause functional damage to it, then it's not covered. It has to cause functional damage to the material to where the roof doesn't perform well anymore, or the siding, whatever it might be. So I haven't seen that endorsement in California, but I wouldn't be surprised if we do soon, because it's been approved in other states. It's obviously being effective in restricting coverage. And that same endorsement could apply to wind damage on a roof potentially, right? And so all that to say, when decisions like this happen, they can have an effect across the industry of claims.
I mean, I have a way to put it. I mean, even if it doesn't legally have precedent in another state, it will effectively have precedent as far as the insurance company's behavior, meaning that the carriers can use those decisions and deny your claim, even if it is not a rightful denial, and then say, fight me in court about it. You know, that's how it can affect, before it becoming actual bona fide law, it could affect the practices.
Yeah, absolutely.
And it can also motivate like which claims they let get to trial if they're trying to get a similar ruling in another state, right?
yeah.
If it's something's being effective, they can be like, hey, yeah, like we're not going to settle this one. We're going to let it go to trial because I think we can piggyback off that and now expand its area of effect.
Yeah, I had an attorney friend tell me not that long ago that he got the sense that a lot of insurance companies were pushing a lot more claims to trial because they want certain things to be fought out in court to try and get some more case law decided in their favor. And so I can't remember the exact issue I was talking with him about. It had to do with water damage and rain and wind. And he was essentially saying on that dispute, he wouldn't be surprised because sometimes as a public adjuster, we'll hypothesize and try and wonder like, well, should we get an attorney involved? They can file a lawsuit. Maybe that will bring the insurance company to the table. Maybe their attorney will want to settle this claim and it can be settled before trial. Like those conversations happen, right? And so I was having this conversation with an attorney about a specific claim and saying, do you think if a lawsuit was filed here, it would bring them to the table to want to settle? And he was like, honestly, I don't know. I would say before the answer was an easier yes, where now it seems like more and more they're wanting to see these things go to trial. Joe asked a follow-up question. Is it better to sue them in local, state court, or federal court? Again,
this is getting squarely into attorney zone.
But I mean, it's definitely better. I mean, we're not giving legal advice and we're not representing anybody and talking to an insurance carrier, so we can pontificate a bit, but you definitely want to keep it in local court, federal court.
and all of our attorney friends tell us
And that's what all of our attorneys tell us is that, in federal court, we have people that are appointed for a lifetime that kind of can do whatever they want kind of situation. And a lot of their personal opinions have a lot more effect on it. And who knows who's paying their bills and things like that. And it just takes a lot longer. And so most of the attorneys that we work with do their darndest to keep it in local court.
No apologies, Joe. Appreciate the questions.
Yeah.
It's awesome. Cameron, what happened to you?
I don't know. My camera just turned off for some reason.
And mirrored. It's very
That's
interesting.
weird.
Let me see if I can get that. I was odd. I'm not sure why I did that.
Yeah, but I can also second that is the sentiment that I've heard, and like oftentimes like naming like whoever you can to keep a case in your jurisdiction is worth considering.
Yeah, and there's some carriers that try to get it to federal court as fast as possible because they know that they have a better chance.
Yeah, that's what I was about to share as well. Essentially, like there are attorneys that I have floated cases to where they are making a decision as to. There I go again.
That's all right. You can keep talking about it.
I'm gonna go ahead and turn it to my other camera here from my computer. That one won't turn off. There are attorneys that I've floated cases to that have made decisions as to whether or not they will even take them based off of the chances that it might go to federal court.
Mm-hmm.
And so, and an attorney can guess about this by what Chris was saying about who you are naming in the lawsuit. Is the insurance company based out of the state where you're filing the lawsuit? And questions like that. And every attorney I've talked to is typically desperately trying to keep a case from going to federal court. So that would be my guess there, Joe, is that if you did need to sue your insurance company, that your attorney would want to do it in local rather than federal court. Aaron, I'm going to go back to the question I was going to ask you. We've now been talking about this case for 45 minutes. That's crazy.
I mean, it's insane.
It's insane. I know. Yeah. It's,
and like, it's so consequential. Like it doesn't like it similarly to like when an insurance commissioner's office like closes their investigation on a claim, and then the carrier treats that as like a blessing, like, oh, we didn't do anything wrong. The insurance company like wasn't able to find fault in what we did, which must mean that we're operating within the law.
Yeah, I'm actually going to have you talk a little bit more about that. So I wanted to ask you about, so you as a public adjuster working in North Dakota are currently dealing with utilizing the Department of Insurance and complaints to them within a claim dispute. And we were talking earlier about what role does the Department of Insurance play. You were talking about how it seems like oftentimes, you know, their teeth, their power, their authority seems really limited within a dispute. Talk about your experience in a much smaller population-wise state like North Dakota, and what you're trying to accomplish there with the Department of Insurance.
Sure.
The claim.
So North Dakota is really unique, right? In that, like, I'm the only public adjuster here.
The only resident public adjuster there.
Well, yeah, and there's some other people who hold licenses, but I'm the only one that lives here and actually has claims. And according to the continuing education office, I'm the only one that's keeping it up. So, but in any case, so it's unique in that way, and it's like it's new. Like, we haven't had public adjusting for a long time, so we're kind of getting to kind of invent the wheel a little bit on this. And then our commissioner, John Godfrey, is the president of the NAIC, right? So there's potentially far-reaching effects of what we can get decided here because he's got a lot of influence and can kind of spread what we're able to do. And then the other factor that makes North Dakota different from California, for example, is like our code is really light. We haven't defined everything out. Like it'll say good faith and fair dealing and just let those stand, and like doesn't go on to define what actions constitute that, right? It's just super light. Our North Dakota's entire state code is one document. It's called the Century Code. They codified it and just shoved everything into one document. So it's a different beast. But all that said, so we have, like, I'm involving them in a dispute, and they did what I just mentioned, right? They closed the investigation, and I was like, no, you can't do that. Here's what happens when you do that. Can you please reopen this? And they've been really great. And
explain why you were asking them to reopen it, because you made the case to them that you were just talking about, but reiterate that real fast.
Well, essentially, the carrier will take that as like, oh, I'm good with what I'm doing. They can interpret it as approval, whether they legitimately interpret it that way or just represent it that way.
Why did they close the case? And what's the reason? It's the same reason that we get out here in California, but why did they close it?
And not just California, it's almost every state that we deal with the DOI. And
real fast too, for anyone listening, we're talking about filing a complaint to your Department of Insurance. This isn't your claim. You have a claim, you have a dispute, and in their denial letter, they'll say, like, if you have an issue, go ahead and talk to the Department of Insurance about this. And then your Department of Insurance has a website where you can file a complaint. So Aaron the client filed a complaint.
No, I filed it.
Oh, you filed it on behalf of the client in North Dakota. So then they closed that complaint for.
Oh, so typically if they cannot find a violation, right? They basically have a limited mandate, as we've discussed. And if they cannot find that they are breaking the law and violating insurance code in your state, then the insurance company can't really do anything. And our code specifically, what makes it difficult is it has and many do, it'll establish a pattern of practice that is got to be established to establish, for instance, bad faith, which is what I'm trying to establish on this one. And all the evidence can be there, but they're, again, mostly focused on the aggregate. They're most potent as far as their authority and ability to do things prior to an individual claim, when they're figuring it out at the policy level on what gets approved, when the insurance company is generating the policy. And then after that, it's most effective if they have a large body of evidence in which to define that the insurance company is operating in a pattern of practice that's inappropriate and not
Over
in alignment.
multiple claims, not just one claim. That's the thing.
So it doesn't define it in North Dakota specifically. It just says pattern of practice in the same way that it just says good faith. And so I am trying to say, no, like, if we're going to have good faith in there, it's like we need to be able to enforce it. We need to be able to define what doesn't meet that definition. I think it's great that we let those terms stand on their own. Let's actually hold them up. And then similarly, a pattern of practice. So I ran this claim up and down the chain of command at that carrier and was able to demonstrate that it's systemic. Like this is a clear pattern of how they interpret their duty to the policyholder. And so that's what I'm trying to establish as the pattern of practice. It's that like I have senior management, I have customer service, I have, like supervisors, I have all of these different levels throughout the company who are independently putting forth the same bad faith actions. And so that's, yeah.
And what was cool about that one is that Aaron made the same argument he mentioned a minute ago to the Department of Insurance, essentially saying to them, hey, if you step away from this, the insurance company will take that as a vote of confidence that they're not doing anything wrong. But the Department of Insurance had essentially let you know, like, hey, you're making really good arguments here. Like it, like essentially signaled to you, like, it looks like something might be wrong here just outside of our jurisdiction to do anything about it.
Yeah, they encouraged me, like they always, like every state does, to file a lawsuit. And I'm like, look, that can't just be the answer to everything. Like you have a mandate. Let's figure this out. And they've been amazing. Yeah.
And this is where I would encourage any other public adjuster that might see this, regardless of what state you're in. He made that argument to them and said, hey, if you stand down too early, it's going to be utilized as weaponized essentially against the policyholder in this instance, that the insurance company is not doing anything wrong. So can you please take another deeper look at this and see if it is within your mandate to do anything more? Right.
And I've made similar arguments in California. Like it just hits a wall. North Dakota is responding differently. Yeah. So it's like, and some of that might just be who you're talking to, right? Maybe there's somebody else there who has more authority. But yeah, there is that your mileage may vary on that one.
California, you're going to have a hard time getting anything across, but in other smaller states with less volume, it's probably more likely.
Yeah, but we've all gotten the same message out here in California. I've had phone calls with Department of Insurance, consumer complaint representatives who have essentially said the same thing, right? Yeah, it looks like something is going on here that doesn't seem right, but we can't put in writing that we even think that. We can just say that we looked at this. It's so funny because what will happen when you file a complaint? You file a complaint to the Department of Insurance, whether it's a public adjuster or a policyholder filing that complaint. It outlines, here's what's happened. Here's what I think is wrong. If we've helped the complaint be filed, it'll be, here's the codes that we think are being violated in your state code. And can you please do something about it? And the Department of Insurance almost every time will come back and say, okay, we've a few weeks later, they'll come back and say, we've sent your complaint to the carrier and let them know that you're upset about these things, essentially. And then they say, we're going to give them a chance to respond. And then the carrier responds and typically just sends another version of the denial letter or whatever it might be, right, of their previous letter, maybe with a little bit more detail. And the Department of Insurance response to that is, okay, they gave you an answer, right? They don't pontificate. They don't give an opinion as to whether or not that answer is justified, whether or not it makes sense within the insurance code. And when you ask them to, in here in California, at least the answer that's been given is, we can't say whether or not we agree with this, because that might be utilized and weaponized against the insurance company in future litigation, right? That the Department of Insurance has an opinion that this was wrongful behavior.
They won't even tell you if they took corrective action.
Yeah. Yeah, exactly. You don't get to know if they.
Yeah, if they fine them over it, you
Uh-huh.
don't get to know. Though, from what I understand, most of those things happen in like quarterly closed door meetings where they review the body of complaints and make a, it's a totally different ball game. I do want to answer Joe's last question about the statute of limitations on, or at least that's how I'm interpreting it.
That's how you're interpreting the question.
on a claim that was partially denied. That typically it's tolling. So if the claim's open and it's being reviewed, that will extend that timeline. But your policy, if you're in a disaster zone, or if it's been declared a state of emergency, there's extensions in some states. Like in California, you're going to get 36 months. But it's usually, so the time that the claim's open and being investigated is like an internal thing that the carrier gets to just play with. They get to toggle it on and off. We're working on it. We're not working on it. Sometimes they do it every time they send and receive an email. Sometimes they send and receive emails and don't change the status. Sometimes they forget. Sometimes they leave it open. It's like, I don't know why they're allowed to make it matter when they decided that the claim was open and closed, but it matters.
But tolling, just so you know, tolling is not relevant in every state. And I didn't know this, and I know it more right now. Matthew Mulholland just put out a video talking to Remington Huggins, I think it is, the attorney that he works with really often, talking about statute of limitations in Georgia specifically, because there, if I'm remembering correctly from his video, it does not toll. And so what Aaron,
2 years is 2 years.
2 years is 2 years, or a year is a year. And so in the summary of what Aaron just said, whenever your claim is open, the statute of limitations is not running at all. It doesn't start until they close your claim. And if they reopen it, it pauses, right? So Joe, you're asking, what if it's been 2 years? Well, if in your state, you have 2 years to file a lawsuit, and it's weird because your policy will typically say you have 2 years from the date of loss. But if you're in California, which is a tolling state, what that means is you have 2 years from the time they close your claim, right? And they end their investigation. And so a lot of times your claim is open for a whole 2 years, and then they finally close it, and then that 2 years starts then. And in California, the state says that the statute of limitations is 2 years, but for some reason that I have no idea about, if an insurance policy says that we want it to be 1 year, not 2 years, the insurance policy prevails, and the statute of limitation is only 1 year, which pretty much every insurance policy that I've seen in California takes the opportunity to say that, because why wouldn't they? Except for in a disaster, they don't get to enforce that, which is also weird. It's like it switches back to the power of the state when it's in a disaster.
It's a mess. It's an absolute mess.
But all that to say, it'd be something you'd want to know for your specific state, because the tolling rules are different, and that it's actually really relevant in the conversation Matt Mulholland was having, because he was saying the carrier can play its own games with that, with you as the advocate or the policy holder. If in the way that they'll do that, and we could all understand this, is that say you're at 9 months or so into a claim that has a 1 year statute of limitations. And so you're thinking, hey, I may need to file a lawsuit just to keep my statute of limitations available. Because once you file a lawsuit, then you're good, right? The statute of limitations has been met. You can keep negotiating your claim at that point. And the lawsuit's going to take forever, no matter what state you're in, it seems like. So, but a carrier, imagine if you're at 9 months and the carrier comes to you and says, hey, let's try and work this out. We think we can come to a number. Let's meet at the house in a couple weeks. We'll bring our contractor. You meet there a couple weeks later. Contractor seems workable. Then, they say they're going to deliver an estimate. Well, that takes 4 weeks to get there. And then all of a sudden you get the estimate and it's only added 10% to what you thought. And then now you've just lost another 6 weeks in the statute, right? and where you thought, and then, but then at that point, what if you think like, well, let's maybe work this out in appraisal. Appraisal does not pause the statute there. The statute keeps going, and appraisal in and of itself takes as long as a lawsuit, even there. So all that to say, a carrier can kind of play games with the process. And I think that I don't think it was in Georgia that they were saying, but like the power is really taken from the policyholder in states where they can force appraisal prior to a lawsuit.
Yeah.
So they can, if you try to file a lawsuit, they can force you into appraisal first before you can move to a lawsuit. So all this to say, Danielle talked about we should look into some of these details before next week, which is a great idea to go over these some more.
Because we are at our hour, and Danielle's not here though. She is now. Oh, she was covered by
She was hiding from the company.
Yeah, no, I knew she was. I was just teasing.
Yeah, I think it's a great idea, Danielle, to review some of the complaints from that have been sent to the Department of Insurance and the responses from them. I think it'd be eye-opening.
I have a bunch of them.
Don't we all? Don't we all make a book with the complaints that we have? Well, yeah. Anyone that joined us today, thank you. If you did not hear at the beginning, Tugboat.claims is an online claims support tool for you to use throughout your claim to help you navigate any of these types of issues as well. Chris and Danielle work with Waypoint Adjusting, a public adjusting firm based in California that takes claims primarily in California, but also in other states as well. And super happy to have everyone's questions. Joe, Emily, thanks for dropping in your questions. Always appreciate those. We will be updating our users at Tugboat. Chris, Danielle, I'm sure you guys will be updating your clients at Waypoint in the coming days with this California Fair Plan news, which is not good news, but the fight continues. There's always more advocacy for us to be doing, right? There's always another step that can be taken. We don't want people to be discouraged and to give up on advocating for their claim. It is almost always worth it to keep advocating for your claim while there's still money on the table. So
Joe and Emily too, since you guys are here often, if your friends and stuff have questions, because I know especially Emily, you're right in the middle of the thick of it. Remind them to come in here and ask us. This is like the easiest way to get multiple brains on your situation. So
yeah, for sure. All right, appreciate you all.